Item number 1.
May it please, Lordship. Lordship, this is an appeal against conviction in under 302, Lordship.
302. What about the
Lordship,
paper
this
book?
matter, Lordship, the paper book is not ready. We are preparing, Lordship. We require 2 weeks' time, Lordship.
Any motive, retaliation, murder, for the reason for the murder, sudden provocation,
Lordship, here the
murdered wife, huh? Or child.
on the basis of the testimony of a child, Lordship. He murdered the mother of the wife. So, Lordship, on that ground, Lordship,
When will you file that?
Lordship, after 2 weeks, Lordship.
In July. Yes,
Much obliged.
Legal lands.
filing paper book.
Item number 2. Obliged, Lordship.
In item number 2, Your Lordship, I am appeared through VC for the caveator.
Yes.
May it please your Lordship. Lordship, the present appeal is under section 13A of the Commercial Courts Act 2015.
Commercial Courts Act, yes.
Lordship, this is sailed against the order of the learned judge, Commercial Court Shillong, which is passed in the miss case number
37. 37. This 37, 37.
No, this is under section 13A of the, this is a appeal, Lordship. Against the order of the learned judge, Commercial Court Shillong, passed in the miss case number 2 of 2023 under order 722D of the CPC, judging that this appeal file is time-bound. The appeal was filed on 21st of March 2023, Lordship. And after this suit was filed, the defendant respondent appeared, Lordship, and filed their show cause, written statement and also miscellaneous petition under order 7 Rule 4D, stating that this suit file is time-bound. That is the main contention in this appeal, Lordship. Now, my humble prayer here in this appeal is that the learned judge made a serious mistake in as much as while taking into consideration the Honorable Supreme Court's order dated 10/1/2022, by which the learned Honorable Supreme Court excluded some certain portion from.
That is pursuant to the orders of the Supreme Court.
Yes, Lordship.
Yes, 2 years period was excluded.
Yes, that is 716 days, Lordship.
Yes.
Now, what happened? The learned court, in the show cause reply against the petition of the respondent, has accepted otherwise all the contentions what I made before the Honorable Court. But a serious mistake has been caused in the hands of the learned judge, that in assessing the remaining period of limitation, the Honorable Supreme Court directed that it should be assessed at 3/10/2021. If there is any remaining period, but the learned court made a serious mistake. It has assessed the position on 15/3/2020. Means when the COVID period or the pandemic just started.
Suppose
That's a big mistake.
Suppose you
It's a
appeal.
perverse finding, Lordship.
Correct. If the limitation falls during the COVID period, that period is extended.
Lordship,
Yes. You're right.
now, Lordship, if I am allowed to proceed further, that the learned court has assessed the position wrongly instead of making it on 3rd of October 2021, when it propounded the date at 15/3/2020. And there the learned court has found that this appellant is having 4 months, 21 days time. So according to the Honorable Trial Court below, that within this 4 months, 21 days, the appellant should have filed the regular title suit, what it was filed. And that is the perverse finding, Lordship. I may allow to be submitted, Lordship. The learned trial court made a wrong finding that the plaintiff appellant had 4 months, 21 days as remaining period of limitation as on 15/3/2020, according to the Honorable Supreme Court order dated 10/1/2022. And the calculations so made by the learned court, the limitation period had ended on 22/7/2022, and even excluding period of 154 days spent in the mediation and the settlement proceedings cannot be considered as
Where is your
the
friend?
Lordship.
Your friend was here?
Yes, Your Lordship, so far the admission of the appeal is concerned, we have no objection for issuing notice.
That
But
is
some
right.
of the documents, which are part of the trial court has not been annexed with this memo. of
Anyhow,
appeal.
only if
So
you are
at
concerned
pre-
about the limitation,
Yes, yes.
you are concerned
So,
about
Your
it's a
Lordship,
legal question, how to
Yes.
calculate a period of limitation.
yes,
If it
yes,
falls
yes.
within the COVID period, after the expiry of the period granted by the Supreme Court, the remaining period will have to be taken into account for the purpose of calculation. That is
But,
all.
yes, the delay is more than what even the trial court has calculated. But even that, after exclusion of the trial, the delay by the period of which the Honorable Supreme Court has cited, it is more. So I would pray that we'll file a short objection to that only on the point of delay. Your Lordship will fix a date for hearing. We will like to appear in person before Your Lordship and gives a tabulation of the entire sequence of dates.
Number, you know. Yes, number.
It has been numbered as 1 of 2020-24.
Sometime
Lordship, the matter is very simple. My learned senior friend is unnecessarily dragging the matter, Lordship. I just conclude the matter, Lordship's best satisfaction, Lordship.
see, let them file a counter.
All right, I have no objection, Lordship, when my learned friend comes and physically makes his submission. I have no objection,
For allowing the appeal,
Lordship.
we require a counter. For dismissing, counter is not required.
No, Lordship, nothing. If I am allowed, Lordship, asking my little patience from a learned senior, I will just, if I am allowed,
You would have seen the Madras High Court ruling 2 days back
Lordship.
with regard to habeas corpus.
Yes, Lordship.
The habeas corpus petition was allowed by one judge, Swaminathan. The other judge, Justice Balaji, said unless the other side is given an opportunity to file a counter, you cannot straight away allow the petition.
Also, Lordship, let them make a counter. I have no objection.
Understood.
I have no
See,
objection.
that 2 years period should be excluded. After the 2 years period, if the limitation period, balance period is there, you are well within time, your appeal, the court should have entertained the matter.
Yes, Lordship.
If it is beyond the period of limitation prescribed under the Act, his contention has got to be accepted. Let them find, you also give the list of events.
I beg to submit, Lordship, in the tabulation I have made, I have come with a synopsis of my argument on that day I will submit it. I have chronologically, I have.
Sir, you are admitting your matter. You need not argue the final hearing. Let them file a counter.
Yes, let them file, Lordship.
Item number 3.
My Lord, My lord,
First week of July.
say 27th of June, subject to your lordship's convenience.
27th of June. So you will be filing your reply that day.
Yes, yes, we'll file our reply before that, and we'll mail the copy to my learned senior friend.
Yes. Pose the matter, admit notice, pose on 27/6
Yes, your lord.
to enable the respondent to file their objections.
We are deeply obliged, your
Thereafter, the
lordship.
date will be fixed for hearing.
We are obliged, your lordship.
Item number 3.
His Lordship. This is an appeal against the order of the learned single bench, Lordship.
Against?
The order of the single bench.
Oh, yes. I think we know the matter.
Lordship. There's one fact of the matter, Your Lordship. May I have the kindly want to take you to page 56.
Huh?
Page 56. Just want to have one para.
Page
Page 56, para 8, my lord.
66.
56, my lord. 56.
Five.
Yes, of appeal memo.
Yes, sir.
May I just read, Your Lordship. I want to draw your Lordship this very important point which I would like to point out. That petitioner begged to state that the Marakapara Akang originally belongs to the Ranji Michik of Ningwenja clan and the
and the late Asimarap of
Where reading, sir? Last paragraph.
yes, the para 8, my lord. Para 8. Para 8.
So originally, yes.
Yes. Petitioner beg to state that the Manakapara Akang originally belongs to Ranji Michik of Ningmanja clan and the late Asimarap of Mrong clan, and upon demise of the late Ranji Michik and the late Asimarap, their only son Arong Sangma borrow money from the other clan by mortgaging the Marakapara Akang, and in course of the time, due to the huge debt which had incurred by the said Arong Sangma, there was a time that the position of the Marakapara Akang was on the brink of alienation to other clan, and the matter went up to governor in council. When the matter was adjudicated by the deputy commissioner by following the practice of Garo custom, and with the arrangement being made, Sri Mansingh managed to repay back the loan amount which was taken by late Arong Sangma from the other clan, and was able to save the Marakapara Akang from being alienated to the other clan. Lordship, I read this particular part. I just wanted to point out my contention of a submission before here is, here the fact of the matter, the crack of the case, the core issue of this petition, right from the Landed Court below, from the EM to the CM, here they are saying that this Marakapara Akang, that my Akang was saved because of the predecessor of the respondent have paid the money on my behalf. That is a serious allegation, Your Lordship. They are saying that my son has borrowed some money from the other clan. That here the petitioner is a predecessor of the petitioner, the Arong Sangma. Their allegation is, Lordship, they are saying that my son has borrowed the money from the other clan, and due to which I am not able to repay the money. So the private respondent on my behalf, they have paid the money, and they have acquired, after paying the money, they have saved the Marakapara. That is the allegation against me.
Case 1935.
Yes,
61. That's the case, you know.
Lordship.
Yes, we have heard.
But one of the things is that there is a basic principle of trying the case. I'm not saying maybe even that 35 years, they should have a procedure, they should have a proper procedure, like framing of issue, whether there is a really 35 years. 35 years, there was a loan, whether I have really borrowed the money, all those things, there is no letting of evidence, there is no framing of issues. The framing of issues never discussed. There is no proper document to show, because this is just an allegation. Because we have been pursuing this case, Your Lordship. Their allegation is the main contention of the private respondent is saying that since I have left the, I have abandoned the case for 35 years. But I'm strongly opposing to this, Your Lordship. My only humble submission, Your Lordship, because the CEM of GHADC in its order dated has already clearly on 5/7/2019 is remand this matter to the EM. EM only for framing of issue, and to framing of issue, giving opportunity for retry the case, Your Lordship. So my only humble submission is that this matter can be remanded back to the GHADC for proper adjudication of the matter, Your Lordship.
Yes.
Because there are a lot of allegations has been, which I strongly deny, Your Lordship. It can be remanded back, let it trial, and if I fail, they can decide the matter. But only here, what my submission, my only concern is that procedure have not been followed while trying the cases. So only I'm saying that opportunity may be given. I'll go back to the lower court and I will establish my case, Your Lordship.
Yes.
That is my submission,
What was this? Yes.
Lordship.
Item number 5.
Most blessings, Lord.
Where is your friend? Where is your friend? This is the matter you want to tie.
Yeah, please, Your Lordship. This is
Tribunal.
yes.
We have come against
The time has expired.
my for disposing of the representation.
Your Lordship, this is the first time we are appearing. We are yet to file the wakalatnama, so during the course of the day, we'll file the wakalatnama. Before passing any adverse order, I request some time to be given for the hearing.
What is the adverse order? We are going to ask the tribunal to decide the matter.
Yes, Your Lordship.
That's all. That's what we said it last time.
Yes, Your Lordship.
What is going to be? Your designated senior. Where is the instructing counsel? Your designated senior advocate.
No.
Oh. Yes. I think last time we dictated the order, no? I think this is a matter where
My lord.
I think I have dictated the order.
20th March order, my lord.
We have not signed it. Somebody, I think we dictated the order. Where is the order? Who has taken it?
That is the subsequent matter, my lord, not this one. The next one of them.
Next one.
But in this matter, my lord, 20th March, your lordship is passed a detailed order, my lord.
20th March.
My lord.
Your Lordship, we have yet to receive.
1 minute. First we'll go through it.
Yes.
You have read the papers.
Actually, we
You
have.
also read the papers. See, they wanted the representation dated 2/2/2023 to be disposed of.
Yes.
That's the only prayer they want.
Yes, Your Lordship.
What is the harm?
Sir, actually, Lordship, before,
Suppose we dismiss, what will happen?
sir, he lost the opportunity because already it's been more than,
Not correct.
sir, actually,
We'll give them 2 weeks time to pass orders.
Well,
We'll give them 2 weeks time to pass orders. Failing which you are entitled to continue the proceedings in the contempt proceedings pending before the tribunal. You cannot have the Democrat sword hanging on your head and say that you have to do it and you will punish him. What is the purpose?
so I'm the respondent in this matter.
We know that. We know that you are a respondent.
Your
Let
Lordship, we
me
have filed the contempt petition only when they haven't.
see. They have not complied with the order of the tribunal.
Yes,
that is
Your
the reason why you have proceeded with the contempt in terms of the Central Administrative Tribunal rules.
Yes, Your
Contempt rules, correct?
Yes, Your Lordship.
That is one aspect. Now they say they are given 2 weeks time.
6 weeks times they were given.
No, not 6 weeks time. No, already 2023. 6 weeks we are not going to give. We are going to give you 2 weeks only.
Yes, Your Lordship.
Sir, you have to pass the order within 2 weeks.
within 2 weeks will pass.
Not beyond that. Come. Though the respondent is contended that the petitioner herein is procrastinating the proceedings and that the order of the tribunal has not been complied with and that the period of 6 weeks time granted by the tribunal has already expired. Come on, knocking at the doors of this court, challenging the order of the tribunal belatedly and try to defeat the contempt proceedings would amount to abuse of process of court and that the writ petition shall not be entertained and same has got to be dismissed. Full stop. The counsel appearing for the petitioner reiterated the contention made on 23/2024 and submitted that if 2 weeks time is granted, they'll pass orders and comply with the orders of the tribunal. Full stop. In response, 6 weeks time. In response, the counsel appearing for the respondent would submit that further time, for a grant of further time is going to defeat the purpose of the order and that the court may consider the grant of time to file the objection to the writ petition filed by them. When this court posed a question as to whether any purpose is going to be served as the respondent are seeking time to pass orders on the representation dated 2/2/2023 he submitted that the time sought for by the petitioner may not be granted and lesser time may be granted so that it will give a quietness to the matter. So taking note of the submission to both the parties, we expect the petitioner to pass orders on the representation dated 2/2/2023 within a period of 2 weeks from the date of rest of the order. And on the after hearing the applicant before the tribunal. We also make it very clear that on the specified date, the applicant before the tribunal is expected to appear before the authority. Full stop. In case he is unable to appear, he may forward his representation, additional representation if any, which has got to be taken note of, and orders shall be passed within 2 weeks from the date of rest of the order. So see, additional representation to be filed within 5 working days. In 5 working days, and they should pass orders within 2 weeks from the date of rest of the representation. So they'll give it on. Full stop. The tribunal may proceed with the contempt proceedings in accordance with law in case of failure to adhere to the orders of this court.
Much.
Item number 6.
Yes. What is the matter about?
Your Lordship, the matter.
Coming up for admission.
Yes, but we have come to this
But this is the matter, my lord. Your Lordship has in fact passed an order. But only the respondent number 3 was not served, my lord.
Oh, yes.
we have taken step, Your Lordship, and we have also.
With regard to grant of allowance at tribunal recording the applicant. Yes. Where is it served?
We have taken steps through court, as well as we have given, as we have been allowed to take private notice, we have sent them an email attaching all the documents, the order, the writ petition, this, if I may allow to pass on the email.
But service through email is permissible. It's not a proper service unless the rules are amended.
High Court rules do not, I don't think it's permit, my lord.
But we have taken steps, we have taken steps through court also.
Where has it served?
The AD is
Private
still,
notice.
AD is still awaited. Private notice by email we have taken, but not
See,
through.
we have not said through email.
Yes,
Private means notice means in accordance with the
Yes.
rules. Is it not appellate side rules?
The AD is still awaited.
AD card has not been received. Yes. You already sent it by post.
Yes.
Is that right? The counsel appearing with the petition would submit that he has already sent the private notice through post as well as through email. Email has been.
I stand corrected, only by email, but through post is through court process.
So he has sent it through email, but he has not taken steps to send it by post. The court records show that acknowledgement card is awaited. And the notice sent through court is yet to be served, and the registry has made an endorsement that the acknowledgement card is not received. Who appeared for the
Before the
this
tribunal,
is a writ petition against the order of the tribunal or
Against the order of the tribunal.
Central Administrative Tribunal?
Yes.
Why did you serve the counsel who appeared before the tribunal?
And then I'll make an endeavor.
The petition is also permitted to serve private notice through post and also served notice on the counsel who represented the third respondent before the tribunal.
Right.
Was the matter on, today we are on 27th. Shall I have it on 13th?
Yes.
13th.
Right.
It's very simple matter. We can set aside the order and
Restore
remit the matter.
Obligation, Lordship.
Yes.
from the list. Item number 1.
Well, there's an application seeking condonation of delay, so notice would have to issue.
How many days delay?
But 665 because most of it was spent in preparing some analogous proceedings, which
It's on the other
culminated.
side.
Notice has not been issued, your lordship notice would have to issue.
Notice. It is returnable by how many days? 2 weeks?
2 weeks, village.
13th.
That's
13th.
Liberty may be granted to us to serve Dasti
Yes, yes,
in addition.
private notice is also permitted.
Right.
Item number 2.
May it please, Your Lordship.
Yes.
Lord, I have concluded my argument. Respondent was to respond, and I have filed my written submission also in this matter, my Lord.
Yeah, we got it. Better you be here. Your present.
Lordship may have it after 15th June, my Lord, any day after 15th June.
Your presence will be better. Suppose we have any clarification.
Right. Yes, my Lord.
We have no. Yes. What's the matter for the respondent arguments? In the weeks 18th, 19th?
Yes, my Lord.
Let you know.
18 is fine, my Lord.
Or thereafter?
Any date, Your Lordship, 18, 19,
Yes,
21,
yes.
22, any date.
Yes. You give the date. Yes.
Grateful.
Yes.
From daily list, item number 1.
Please, Your Lordships.
All the three are connected.
My lords, connected matters. My lords, this is a matter where the petitioners were appointed as home guards, my lords, in the office of the Accountant General Shillong. Now, my lords, during currency of these matters before your lordships, my lords, 2 of the petitioners have retired. Only issue that remains is, my lords, regarding some monetary payments to be made in respect of the petitioners in the first 2 matters, my lords. Third petitioner is, of course, in service. They had earlier come before your lordships by way of a writ petition seeking regularization. The lordships had held, my lords, there is no question of regularization. However, my lords, they should not be supplanted with another set of temporary employees, and they should be given the benefits in terms of whatever is otherwise applicable to them. So that is the limited issue.
Why don't you give compensation and give a quietus to the matter?
My lord, the main.
Having extracted work for so many years.
6 to 9, my lord.
Sir?
The main contesting respondent is respondent number 6 to 9, who is the office of the Accountant General. So,
Who is appearing?
Mr. Devnath was appearing for the.
Huh?
Mr. Devnath was appearing for the respondent 6 to 9, my lords.
they are the contesting respondent.
My lords, what we've done is we've taken out a calculation of what is otherwise they are eligible to get. Of Mr. Devnath is saying.
Why don't you give some compensation and give a quietus to the matter? Having extracted work. See, these are all, service matter, it's only depends upon the compensation. Ultimately, they want money. Give a quietus to the matter.
Your Lordship, in this case,
See, you must understand you are being of a state, and you must also be a model employer. See, now the question of regularization, all those things now, see, everybody is quoting Uma Devi case. And after Uma Devi's case, nobody is dispensing with the services. You require the service of those people. You can't say, I'll give a go-by to Uma Devi's case and appoint, and whenever a litigation comes, I'll use Uma Devi's case. That is not correct. Give some compensation, give a quietus to the matter. Whatever is feasible. Then we talk to him how much they are willing to accept or not. See, 2 persons have attended the age of superannuation. Only 1 person is left. Time. You are the contesting respondent.
Your Lordship, we have taken the service as per this, the contractual methods.
Who is the authority concerned?
Authorities concerned the state to decide.
State?
State to decide the matters.
State, my lords.
State.
It is what the AG is saying, my lords. The Accountant General is saying that it is the state to decide. State is saying, my lords, it is the Accountant General to decide.
So
We
you
were
want
posted in the office of
you
the
ask the 2 officials to appear online. I'll try to persuade them. See, in Tamil Nadu, in Madras, High Court, I had said, I asked the IAS officer to appear online. In several cases, got settled. If it comes through the court, then they may agree. I am telling you, you have to write a letter. They may agree, they may not agree. Suppose they appear, say, give a quietus to the matter. Say it is a win-win situation. Suppose the matter next week. Ask them to appear. Well, the matter is taken for hearing. Mr. Paul, senior advocate, would submit that there are 3, out of the 3 petitioners, 2 petitioners have already retired in the age of superannuation. And that.
next item.
If the relief is granted to the petitioner, they will be entitled to, 2 of them will be entitled to monetary relief, and 1 person will be entitled to regularization. He suggested that if a monetary compensation, a reasonable monetary compensation is offered, he may try to persuade his client to accept. And ultimately, it is for them to decide whether they are interested in it or not. Mr. Khan and so and so appearing for the respondent would submit that they will have to get instructions, and being a state, it is very difficult for the officials to take a decision. In order to give a quietus to the matter, we request so and so to appear through online in order to assist the court to find out the feasibility of amicable settlement so that there will be a win-win situation for both the parties. Pose the matter on, today we are on 27th. 6th?
Sixth, my lords.
6th.
Sixth. Anyway.
That's all. One more.
Item number 2.
Item 2 and 3, my lord.
Yes.
We have taken some time, my lord. Your lordship may have it in third week of June, my lord, in this item 2 and 3.
Lordship.
At the request of the Advocate General. What's the matter? Burning midnight oil.
Yes, my lord. Yes.
Yes. What's the matter? Anytime after 18th. Anytime, any day. We schedule a date accordingly. Any day after 18th, you put.
Yes.
2 and 3.
Yes. Grateful.